my lords and my lady, to address the issue of disclosure, which is actually being attributed to Mr. Justice Raila. And sometimes it's good to tell the truth, because the issue of how this bench was empaneled has not come to light. It is down. They actually knew of it, and based, or should have, they would have found out. The letter which was written this morning, which we have, it was received on the, it was written on the 20th of October, has actually one pertinent question disposed, whether the file was actually taken to the Chief Justice and at what time. So they are actually knowing something regarding that. Then we are dealing with constitutional functions under Article 165(4), which means they were saying only the Chief Justice can constitute this bench. So they actually knew how the bench was constituted, and possibly the only reason we should be given is why the file was taken to DCJ, possibly because of the absence of the Chief Justice. They will have to take themselves to why we have the Chief Justice being the head of the judiciary and the Deputy Chief Justice being the deputy head of the judiciary. In the absence, that's what the Constitution provides. In the absence of the Chief Justice, it is the Deputy Chief Justice who is supposed to do administrative work. Which, and here, let's not reverse what we were told. That as we do in Parliament, you go around in circles to waste time so that the motion possibly is defeated by a fraction of time, which is what they're trying to do. The truth is this: it is well known in practice that the court's administrative functions can be done at any time of the day, including this bench can sit up to midnight without anybody questioning. So the issue of when the Chief Justice, Deputy Chief Justice sat does not arise. As to what happened on Saturday, again, this is purely administrative.
For the Speaker of the Senate, may we be heard? Yes. My Lord, allow me to assist the court. And my Lord, listening to the speech, not an application made by my colleagues on the petitioner side, my Lord, I just want to state that the Deputy President filed his petition on Friday. And my Lord, on the same day, he got conservatory orders. My Lord, he accessed justice in accordance with the framework in Article 48 of the Constitution. But my Lord, justice cuts both ways. My Lord, the respondents on the same day filed an application to set aside those conservatory orders. My Lord, properly constituted, this court has issued directions that those applications be heard today. My Lord, under the Mutunga rules, there is a fundamental doctrine which we are all missing. The doctrine of timely resolution of such kind of disputes, especially disputes that are of immense public interest. So, my Lord, if you look at the application which has been made, or speech made by the petitioners, my Lord, you will see that they want to split hairs. My Lord, the Constitution expressly provides that the Chief Justice shall appoint a bench to sit on matters which raise substantial questions of law. But my Lord, at the same time, that Constitution which requires to be read conjunctively says the Deputy Chief Justice shall deputize the Chief Justice. So my Lord, what is the fuss about it? So my Lord, my request is that the application, this speech by the petitioners is solely meant to delay the business of the day. And my Lord, I request in public interest, my Lord, I request in public interest that you give directions. We proceed with the application. We are here to respond the application for conservatory orders. And my Lord, you also hear our application to set aside the conservatory orders. My Lord, that will make juridical sense and promote public interest. Thank you.
My Lord, if I may just add, this court has the control of the proceedings. And this is a very weighty matter. It concerns the Deputy President of this country. I will not allow everybody to speak, because if everybody is going to speak, we are going to head nowhere. A challenge has been posed on the validity of this bench to sit. This is the direction we are making. The application challenging the validity of this court receipt must be filed within 1 hour and responded to within 1 hour. We will come at 2 to listen to that application.